right. Well, I am Jack Coe, and I'm the faculty director of the International Commercial Arbitration concentration in the LLM program. And one of the reasons I like working at the Strauss Institute is that through its programs and other activities and just the culture that has developed here, we attract international personalities of great distinction. And when that happens, we often try to engage them in conversation and, whenever possible, preserve that conversation. Today, we're very fortunate to have with us Ana Joubin-Brett, whose name may already be familiar to you. At present, she has a boutique practice in Paris. I guess I could call it a boutique practice, specializing in counseling states with respect to dispute prevention, dispute settlement, treaty policies, and all matters related to that. By way of education, Ana did her initial studies at Lyon, where she did a law degree and an international relations degree, followed by advanced studies in law at the Sorbonne. Most Americans will have heard of that famous institution. We at Strauss came to know of Ana first when she was at UNCTAD, which is, let's see if I can recall this, I'm so used to using the acronym, it's the UN Conference on Trade and Development, which most of us get in the habit of calling UNCTAD, where she was in charge of important advisory work with states, not surprisingly in connection with their investment disputes, investment policies, frameworks associated with managing all of those, including capacity building. And I think we first might have met at an American Society of International Law conference ever so briefly. And you were telling me about some work you were interested in talking more about.
Indeed.
And followed then by, we spent some time at a conference in Kiev and some other things. And I, of course, reported back to the colleagues here about some of the interesting work you were doing. And during her time at UNCTAD, not only did she consult with governments from virtually every corner of the world, she was responsible for what today remain on my bookshelf some of the best resources I have, a series of booklets and briefing papers, various kinds, on investor-state disputes, treaty practice and trends with respect to treaties, investment treaties in particular. And they're so wonderfully written that you can carry them on a plane and learn a lot in the course of a short trip. They're very accessibly written in that you don't have to have a lot of background to benefit from reading them, and I recommend them to my students whenever possible. And in terms of accessibility, one can also get them at the website very easily. So it's not as if you and UNCTAD were trying to turn it into a revenue stream. And so I continue to alert my students to that, and they consult those with to great advantage. More recently, Ana was one of the principal architects of the very new, freshly minted rules for investor-state mediation. And I underscore mediation because the field tends to be associated with arbitration. We're going to return to this point, I hope, in a few minutes. I should mention briefly that between the UN that you did for several years and your boutique practice, she was also a partner at the major firm of Foley Hoag, I think I'm saying the second name right, at their Paris office. So she has definitely experienced a wide variety of careers and many careers within a career. But since both of us have this interest in investor-state disputes, and both of us have been laboring in those vineyards, let me just ask, what do you think justifies calling that sort of a specialization? In other words, why is it that I'm entitled to teach a special course on investor-state disputes as distinct from, for example, international commercial arbitration?
Well, that's a very good question, Jack, and thanks so much for first of all for allowing me to be here and to share this conversation with you. I'm extremely happy and honored to be a Strauss Institute guest because that's one of the world's hubs of dispute resolution. So, again, thanks very much, and also for the opportunity of this chat. I'm also interested by your question because I think all of us, being lawyers, we all think that the field of law we're working on is so special and so interesting and that everybody ought to know about it. Well, I think there are a couple of things that make investor-state dispute settlement so special, and I think it has first to do with the parties. We're dealing with states. We're dealing with sovereign states here. So we're not dealing with a usual B2B relationship or B2B dispute, which, lots of businesses are used to settle their disputes through arbitration. States are not. States are generally, immune from this kind of disputes, number one. And second, when disputes happen, they happen among peers, so among states. So I think here that's really what makes this area of dispute resolution, if you want, on the one hand, and this area of international law so specific, is that you have an international animal, which is the state, and you have this inherently private animal, which is the investor, and you're putting them together and trying to find a framework within which both can settle their disputes. First of all, both can establish contracts, and when it comes to a dispute, deal with it. So I think that's the first, I would say, what really makes this area of the law so specific. And the second one, and of course there's the consequence that whatever states do are public policy measures and acts. States regulate, states take measures, states act, and they don't do it with a sense of doing business. They do it from another perspective. So I think this is really what makes it so specific. On the other hand, what also makes it very specific is that in recent years, it has caught a lot of public attention. There have been lots of moves towards more transparency and accountability in this area of the law, so that it wouldn't be negotiated and dealt with without having public scrutiny. And so I think that has, and also the stakes involved. I mean, usually you won't go for an international arbitration when it's about $100,000. So we're talking millions, we're talking billions. At the end of the day, we're also talking compensation through public money. So all of this makes this area so, I would say, fascinating for those of us who have the luxury of working in it, and also makes it also so sensitive. Makes it sensitive to the public, makes it sensitive to the taxpayers. So I would say, if you ask me, it's really about, who are the parties, who are the stakeholders, and, arbitration is not the usual method of settling disputes when states are concerned. So that's pretty much...
That's fascinating. I've been teaching long enough to know that, in fact, since 1983, and if I go back and look at my syllabi for, let's say, international business transactions, I would see that in the early days I was focusing on cases like Elsie, which was a case where the United States brought a claim on behalf of an investor against Italy, the old espousal model. And so today we have this interesting phenomenon, as you point out, of private entities uncharacteristic of international law traditionally, that get to bring a direct claim against a sovereign state.
That's right.
And would you agree with me that, I mean, you as much as said that there are these asymmetries, in the sense that on the one hand the state is a regulator and deals on behalf of various stakeholders and has different objectives than a mercantile entity. And so they have the advantage of being able to sort of make the law, and still they are accorded a certain regulatory space, if we can call it that. At the same time, in what is still a rather novel model, they're now having to answer private claims in a situation where there's another asymmetry, in the sense that only the investor can bring this dispute.
Absolutely.
And there's still a lot of doubt about whether the host state can bring counterclaims.
Yes.
So from that standpoint, there is this asymmetry of the who has standing in the moving party. And so you have one entity that's accountable to the citizens for tax dollars and the way they've comported, they've executed their mandate. You have another entity that presumably is worried about their shareholders.
Yes, absolutely.
With the option of moving forward. And as you say, these disputes are never small.
No.
By definition, you could not, it would not make sense to bring one. Let's focus on this interesting thing you said about transparency. Now, this is all by way of me justifying having a separate course. In teaching international commercial arbitration, one would stress the extent to which hearings are, for example, private under the UNCITRAL rules, and that depending on where the arbitration is seated, and certainly by agreement, the parties can agree on confidentiality.
Yes.
And so it's entirely possible that in international commercial arbitration, a dispute could arise, be arbitrated, lead to an award, which then is satisfied by the giving of money or whatever is called for in the award, and the public would never know, except perhaps to the extent that corporation or securities regulation law requires disclosure.
Yeah, absolutely.
So a strong emphasis on that, and yet the trend is quite the opposite with states.
Absolutely, you're very right here, and I think that is, we can find a reason for that in the choice that was made about 50 or 60 years ago, when deciding that in this field of investment treaties, the method for settling disputes would be patterned on commercial arbitration. You would use arbitration as a way of settling these disputes, because investors are feeling comfortable with this way, and because there is genuine and strong distrust on the part of investors as far as the local courts, the domestic courts of the host state are concerned. And so the model, the pattern was really commercial arbitration. But commercial arbitration comes with a certain number of features, as you say rightly, and it was found when the number of cases began to actually increase, and when states were repeatedly brought to international arbitration on the basis of these treaties, and some commercial contracts that had, or I mean state contracts that had these investment arbitration dispute settlement provisions. At that stage, it was found that there was something which was not quite working, and so a number of issues have been discussed to adapt the commercial arbitration model to how it works when states are involved. And one of the main evolutions, one of the main changes that took place in this investor-state system, as we call it, was precisely to bring in an element of transparency. It was not easy. It took a couple of years and a lot of efforts on the parts of institutions such as ICSID, the International Center for Investor-State Disputes in Washington, D.C., and more recently, UNCITRAL that you were mentioning, where, discussions have taken place for several years before agreement could be reached as to the degree of the fact, first of all, the fact that these disputes would be publicly known, that the outcomes would be publicly available, that there would be access to the public, including to the hearings themselves, that there would be a possibility for amicus, friends of the court, to make submissions. So all of this was part of this trend for more transparency that is very inherent to the fact that you have states parties to this dispute. So, there's been a cultural shift. Those who have been rolling their eyes at transparency and transparency standards, how is there a thing like transparency standards? But, all of them are now accepting that this is an evolution that was required, and that is making this whole system more acceptable, if you want.
I think that's certainly been my view of it. There's an interesting knock-on effect, though, isn't there? Now that the awards are publicly available, we begin to compare what tribunals are saying.
Oh, yes.
About the same piece of treaty language, let's say fair and equitable treatment, or what constitutes an expropriation, or
right.
You could mention many other things, and not surprisingly, we find divergence,
yes,
causing some people to say, particularly states, well, where is the predictability that one would like to have if it's truly a legal system?
Exactly. I think the point you make about predictability sort of resonates with me, having worked on investment policy for a long time. You always hear the same thing. What investors want is a stable and predictable framework. And I would say that this also holds true for states. When states are committing to these treaties, which are international instruments, they also feel that, insofar as states can feel, but at least the negotiators and those who implement and then later on have to deal with these disputes feel entitled to some predictability in what is the way these treaty standards, this treaty language is going to be interpreted, because of the sheer consequences that it can have on their international responsibility and, of course, on having to pay compensation.
That's certainly been my sort of anecdotal take of it as well. The other thing I've noticed, talking about certainty, and if you put it to students, how does one remedy the situation? You can see that states figured out that we need more detail in our BITs, for one thing. So the bilateral investment treaties, which are essentially the promises that the states make to the investors,
right,
increasingly have more and more detail that eliminates certain fringe interpretations, and indeed these BITs, I find, are influencing each other. So you find in, for example, the model Colombian BIT or the Korean BIT language, not unlike what one finds in the Canadian and US.
Yes, that's right.
Saying, here's what we mean by fair and equitable treatment in more specificity. And it's an interesting thing, of course, because there is this problem of the underlying custom. And it's ever been the question to bedevil law students now, is this treaty text a codification of custom, or is it merely a treaty standard? If it's merely a treaty standard, then these clarifications only apply between in this bilateral relationship.
Yes.
If it restates custom, then we have influence beyond the BIT. So,
talking to a restatement expert
yes,
here, aren't
yes, for my sins,
we?
yes. But the second thing, more ambitious, I think, and you and I have talked about this, is why I'm bringing it up, is this idea of some sort of appellate mechanism.
Yeah.
Some sort of, and presumably it's one would have a right of appeal, and the review would not be like current reviews for just procedure and jurisdiction, but actually
Yes.
on the merits.
That's right. I think that's it's probably the next big move. I don't have a crystal ball, but having been involved in this area for long enough, I think this is probably what's going to change, or the discussions that are going to take place in the months or maybe a few years to come. There is a real, I think there's a genuine concern about what is called consistency in the outcome, and states, states are animals that need a lot of time before things change, before even the law changes and the law sink in. Mm-hmm. So there's been a lot of adjustments to treaty mm-hmm. language, and mm-hmm. you're very right that there's been clarification. If you simply compare the sheer size of the dispute settlement provisions of treaties of today to those of the early 60s, you'll be surprised by, it used to be an article which said yes. basically if the parties are not in agreement, they can go to international arbitration. Now we have about 20 plus pages yes. which set the rules of what states and investors are going to use for the settlement mm-hmm. of their disputes. So I think there's a lot more sophistication, there's more clarity, but again, we are, I would say, stuck with a dispute settlement model, which is arbitration, which, an award is final and binding. Mm-hmm. So once you had a bite at the apple, that's about it. You have a decision and you have to abide by it. The problem is that we have this consistency issue. On the other hand, we have other models that states are involved in, and particularly I'm thinking about the trade model, mm-hmm. where in the international trading system we have a two-layered dispute settlement mm-hmm. understanding, which works in the WTO, and trade and investment always or very often go hand in hand mm-hmm. in these treaties. The latest generation of investment agreements are no longer in standalone mm-hmm. bits, but are part of broader trade and investment agreements, free trade agreements with investment chapters, essentially. And so, there is this trade model or pattern, mm-hmm. which is based on, we have panels that will hear a dispute, mm-hmm. and then we have an appellate body. Mm-hmm. And so, these trade disputes, these investment disputes are sometimes, on very similar or related measures taken by the state. Simply they're being interpreted, or they're being brought under another chapter, mm-hmm. different chapter. So there's sort of this divide between everything which is investment related, which will go to international arbitration, mm-hmm. and the trade part of it, which goes to a system which has these two levels. So I really think that, and also we have to take into account that, now that more and more regions are following the same models, you were talking about mm-hmm. the Korean, recent generation Korean treaties or Colombian treaties, and all of them have, at least with the US, have this provision which says that the parties will sit down and work out an appellate mechanism for the treaties. So I think this really shows that there is movement in this direction. There are good reasons for that. I think that's going to happen, and
Well, as
probably
always,
pretty soon.
the devil is in the details, of course. One could set it up on a bilateral basis between the two states, on a regional basis, on a global basis, sort of on some sort of world court model. And I guess we'll just have to wait and see. But certainly many governments are committed to it. As you say, the U.S. model texts all contemplate that in fact they have to allow for it because it would change certain things in the model depending on whether there's an appellate body or not. Which is a nice entree for me to introduce mediation, since this lack of predictability that face both the investors and the states might cause them to wonder up to the very last moment how they're doing in the arbitration, and indeed sometimes they're very disappointed, and that disappointment can be quantified in billions of dollars. And so it's a system in which both sides carry a certain risk.
That's right. It's interesting that you raised that, because a couple of years ago, and you were there, we had this symposium in Lexington at the Washington and Lee University, and there were some preparatory interviews, videos that are still available on the internet, interestingly, and one of the participants in this symposium, I think it was Mark Clodfelter, a colleague of mine, raised this issue that actually unpredictability, the fact that you cannot predict the outcome, is an obstacle to mediation. And it sounded to me like it would be exactly the other way around, that if you cannot predict what the outcome will be, you should rather look for a good settlement rather than a bad award that might come you don't know when, in addition, and cost you a lot of money. So I think there are a number of elements that are aligning here. Firstly, I think very clearly mediation is a way that is not totally alien to these investment treaties, because a number of them, I mean all of them, have what is called a cooling off or waiting or amicable settlement. I prefer to call it an amicable settlement period, which usually goes between 3 to 6 months, and which is meant for the parties to sit down and discuss the matter, settle it, before they go to international arbitration. And the trend has been that in recent years, arbitration has sort of become the only way for the parties to come to a settlement of the dispute, which is binding, which comes from outside. And I see a lot of merits in having the parties work it out together. So I think that's one of the elements, is the treaties allow for mediation. But on the other hand, there is maybe a cultural gap for the time being that's maybe may still need to be, or there still needs to be some work on that. But there's another element that strikes me as very interesting and may bring us back to our discussion on transparency and accountability. I was surprised to see in recent articles and research, academic research, to see the number of cases that actually settle before an award is rendered. And there, depending on, I've seen studies talking about 30%, others about 39% even, of the cases that go to international investor-state arbitration and that settle before this famous binding award comes. So that to me tells me two things. It tells me that on the one hand, it's perfectly possible to come to an agreement between the parties without having a binding arbitral award. And the second point is that I think that the more these treaties and these cases and these arbitrations and these settlements come under public scrutiny, the more it's going to be difficult for government officials and even, I guess, for investors who settle to justify and to say, well, you know, you actually settled this case and you actually agreed voluntarily to pay so much. How did you come to this result? How did you decide that you would, what were the factors and how could you commit to this result? And I think here the third party neutral, the facilitator, as we like to call mediators, is going to be very important because it will show that this settlement, this agreement, has taken place within a process, and that it's not something that was, dealt with behind the curtains, as we say in French, or under the table, but that it is an actual process that has been followed in order to reach this agreement. So like arbitration is a process that gives some definite character to this dispute settlement, I think mediation has the same role to play.
Well, it's a nice way of me inviting you next to talk about the IBA rules,
Yes.
which adds the structure that to some extent was needed in the mediation process, with a particular view to the particularities of investor-state disputes.
Yes.
Tell us a little bit about that.
Yeah, thank you very much. I'm very happy to be the one talking about it to you, because actually you're, together with Margrethe Stevens, you're the founding father and mother of this initiative. You're the one who launched this working group in the IBA and was met with the first eye rolling.
Yes, eye rolling, very important technical concept in the selling of mediation.
Indeed, and with Bart Leggum, we together we took over after you actually planted the seeds of investor-state mediation, and early in this effort. We actually asked ourselves three questions. If you remember, at one IBA meeting years ago, I don't know if it was in Buenos Aires or in Madrid. Anyway, the question was, after having assessed that there was a gap here, that there was a need for an additional dispute settlement mechanism or an alternative dispute settlement mechanism, I think we came to three main findings. One, that what was missing in order to promote or to get mediation that is, as I said, allowed by the treaties. The treaties say that it's possible for the parties to have recourse to other means. What we found was lacking was an actual process that the parties could turn to, sort of rules that would govern, like they do in arbitration, this process. So again, that by committing to going for mediation, or by allowing for mediation to be an option, it would not be a vague commitment. It would not be something that they could not then justify by saying, okay, we are going for it because we have rules that back us in this process. The second obstacle, if you will, that we saw was, as far as treaty language is concerned, we really found that treaties were, they were allowing, they were making it possible if the parties really wanted to, but they weren't really encouraging. And so we thought that this was also an angle we should be working on. And I'm quite happy to say, Jack, before we turn to the IBA rules, that there is a lot of, there are important breakthroughs. Currently, the European Union is now, with its mandate to negotiate, including on investment matters, the European Union has a an annex on mediation, on investor-state mediation, that forms an integral part of its free trade agreement negotiations. And that's not just a line which says the parties may, if they want to, go for mediation. It's a full-fledged mediation set of rules that applies, that the parties want to agree to resort to. So I find this is an incredible breakthrough. The same happens in ASEAN, the ASEAN ACIA, the Comprehensive Investment Agreement. There are other regional treaties that are putting this now on their in the models, or including in their treaties. And I'm quite happy to report that just a week ago I was in Bangkok working with the Thai government precisely on, having building ADR into their model treaty. So I think, a lot has been happening on this. And of course, the third point I will probably talk about a little later, which is to have skilled and credible investor-state mediators.
Yes.
But back to the IBA rules, you were asking me, see, I'm getting passionate about.
Well, this is why we're having this conversation. I knew you would.
Mediation. I think what really characterizes the IBA rules is that while being a set of rules, they're extremely flexible. So they give the parties all the possible leverage and flexibility that is needed, while at the same time catering for, I think, two key interests. One is to really give mediation a chance. And there is this quite unique feature of having a possibility for co-mediation, which I find extremely important, given the big cultural difference you have between government officials on one side of the table and general counsel and sophisticated lawyers at the other side of the table, including the language gap, which very oftentimes is quite an impediment to communicate, of course, and then to come to a meaningful settlement. So that's one of the features of the IBA rules that I find really quite unique and interesting for states and investors alike. The second element, which is really important, is to flesh out the mediation management conference and to give some meat and some items that will serve as a guidance, and which also gives states that want to use the IBA rules in their treaties some frame,
kind of like a checklist, kind of like an agenda, a schedule of what things you might think about.
Yes,
and moving this forward.
What am I committing to? What am I supposed to do now? Which is what is really, one of the things we may have to work some more on. So we've agreed to that. Now what do we do? And I think the third element, which is really essential and so specific to investor-state mediation, we alluded to at the beginning of this conversation, is the confidentiality versus transparency issue, which is so inherent to having sovereign states involved. So the rules are really very mindful of the fact that when you have a sovereign state involved and when you have all these transparency requirements, you cannot just think that this is going to take place in a closed room and nobody's going to ever know about it, because it's public money that is going to eventually be put on the table. So this is dealt with by the rules by having a default rule. The default rule is, if you don't, the fact that the mediation is taking place and the outcome of the mediation are not confidential. But on the other hand, you have the process itself, and you have the way. I'm talking to an expert here, and I'm by far so much to learn and to get into what is taking place within the mediation process, and the way the mediator is going to treat information that she receives, and how the parties are going to. All of this is utterly confidential. And here, I think that's also one of the features that make these rules so, in my sense, so good.
Right, and I think others agree with you. It's a wonderful text, and all that you say is true. I love the flexibility of them, and I like the idea that there is, it generates momentum to actually convene.
Yes.
And therefore, as we always say, the hard part about mediation is just convening the parties, and then once the process starts, it's often very successful. And I've given a lot of thought to the tension between transparency and the need to be in caucus quite privately so that the candor can flow and things can be said that should never see the light of day. And it is a delicate balance.
Yes, indeed.
But it's you are to be commended on this wonderful text. And I know that you won't take credit for it by yourself. There was a lot of subcommittees,
a big group effort,
and I
big
remember
group effort.
One fun meeting we had in Geneva, and some other phone conferences and things. Let's go back to the essential feature. A set of rules is, of course, wonderful to have and adds structure, gives certain imprimatur of the IBA, something to point to that a bunch of thoughtful specialists said, yes, this is our final text on this. But at the end of the day, you need good mediators.
Yes.
And this, in a way, is the next step, because
Definitely.
mediation, I think you would agree with me, has been underutilized.
Definitely as well.
And the focus has been on arbitration, and so one can certainly identify the list of the most active 25 investor state arbitrators, but if someone says to you, please find me an investor state mediator by the end of the week, and I guess the first thing this is controversial, but I've often said to my students, not naming any names, but a world-class arbitrator does not necessarily make a world-class mediator. They're different skills.
Totally agree.
Different. So how would you see, though, what are the next steps in putting together this pool, this list, this panel of mediators?
Well, two things here. The first is that, not surprisingly, now that the rules are out and that there is really momentum for mediation, and like in commercial arbitration, there is a strong push towards ADR. Towards mediation. At the ICC and other institutions, you see clearly that there is more and more of this mediation or conciliation. Not surprisingly, there are phone calls being made. People begin to ask you, in your view, could you suggest who would be good as if we want to appoint, say, on a roster like the European Union is now going to go forward with a roster of mediators and a roster of arbitrators that they have in their treaty. So again, the question arises, who could do that? And so the point is really to turn to people who have, in our subject matter, I think what is important is precisely this subject matter knowledge. It's we're dealing with international law, we're dealing with investment treaties, we're dealing with states, sovereign measures, acts. So there is this dimension to it. But then there's also the village elders, if I may use a term that is being used in this excellent training program you have here at Pepperdine on mediation. And I think that's also one of the aspects, is that you have to find people that will be acceptable to both parties, and that will have both an authoritative but also I would say maybe more than in arbitration, the human skills will come into play. They will have to ensure that people feel comfortable and that they can talk to each other. So we're looking at a variety or a different combination, let's put it this way, a different combination of skills, and they're absolutely and definitely people who meet these combinations. What we need now is to hear more about it, to be more listening more to experiences of negotiations that have been successful, and as I said, there have been plenty. Lawyers that have been involved in these negotiations, academics that have had the chance of talking to both sides, practitioners. I'm thinking diplomats, I'm thinking of people who have done this shuttle diplomacy for many years and have developed a skill here. So I think we're not short of people who will meet this. But as you say very rightly, we have to come up now with offers, so that it's not only about you have rules and you have treaties that enable you to do it, but then where do we turn and how do we do it?
And I think, well, it's interesting. It will be interesting to see who among the arbitrators will be doing both. And there will be some interesting conversations had about when you're wearing this hat. Now, not in the same dispute, but for this dispute, they ask you to mediate. Now you're, and what switch do you turn in your brain to make that happen? Our friend Bart Legum likes to talk about giving the parties cover, and particularly the states. And one aspect of that is the host state needs to be able to point to the mediator as you say, an authoritative person, someone that the stakeholders, that the answers to would say, well, in that case, if this person was, so, but well, we are, it's certainly a fascinating process, and in our next conversation, we'll have to, when we get together in another year, we'll have to see what kind of progress we've been made. But my students would I know, be mad with me if I didn't ask you a little bit about career advice. You've done so many things and so many things well. And obviously being brilliant and working hard has a lot to do with it. But if you had to give some advice to some of my LLM candidates about how to prepare themselves for the future of dispute resolution as we've experienced it, or as one can expect to experience it, what would you suggest?
It's a difficult question. I think that one of the things you really need to prepare yourself for is that there is not one career path. So there's not, you're most likely not going to have one career in your life, but maybe 2, 3, 4 different careers. I don't want to bring it back to me, but I started out selling ski lifts and cable cars in a French company that you probably heard about, Poma. The Poma lifts are also quite popular in the US. And I did that for about 10 years. And then I spent 15 years in the UN. And now I'm working as an arbitrator, as a counsel to states. So I would say, and hopefully that's not the end of it. So hopefully before I retire and enjoy my grandchildren, I'll have an opportunity to do maybe even other things. So I think one of the important, it's difficult to choose one career and think that you're going to be doing it for the next 40 years. That's for sure. But on the other hand, we don't have the luxury anymore of embracing one career and thinking that maybe in 40 years down the road we'll still be working on this. Apart from, of course, some really specific. I'm not talking about doctors or surgeons or. So that's one thing. And the second, which really strikes me as I'm growing in age, is the importance of the human factor. I'm convinced that, you know, the best grades don't make everything, and being a good person, being committed to others, being open to others and to their needs, and doing community service. I mean, going beyond the fact that you know absolutely everything about the writings of, or this case or this award, that's very important, but don't forget that life is much broader than only law studies.
That would seem to me to be an ideal place to put a period.
Yes.
Except for me to thank you so very much for this conversation and for all the insight you brought. And we're just delighted to have you here in Malibu, and we look forward to a continuing relationship, long and enjoyable.
Thank you very much,
Ana.
Jack. Thank you for having me and for giving me the opportunity to be so passionate about international law and international arbitration. Thank you so much.
Our pleasure.
Thank you.